So all rise, I will lead us in the Pledge of Allegiance. Now is the time that has been set to consider an application by Melva Murphy to change the comprehensive plan designation of the subject property from timber to urban, low-density residential, and to change the zoning designation of the property from timber TBR to future urban 10-acre on a property located in Damascus area on Southeast Borges Road. The hearing today will proceed as follows. We will first hear the staff presentation from Senior Planner Melissa Ahrens. The applicant will then have up to 15 minutes to present. And next, I will open a public hearing for testimony, beginning with the public officials who will have 5 minutes each. Then representatives from recognized community planning organizations and agencies will have 3 minutes each. Finally, other people wishing to testify will have 3 minutes each. The board will then deliberate and either render a decision today or set a time to make a decision at a later date. Assisting us in the hearing today is our clerk, Christina Terwilliger, right over here, senior planner, Melissa Ahrens, and assistant county counsel, Nate Boderman. Today, we are holding this land use hearing in person, as well as virtually. If you've joined us on the Zoom app for this meeting and you are interested in providing public comment, we will prompt you to do that when the time is right. The Zoom link and instruction to participate via Zoom are located at www.clackamas.us/meetings/BCS/land-use. You will have the option of providing your comments to us during the public comment portion of this meeting. Be sure to include your name and area where you live. For those attending in person, please fill out a card and give it to Christina, and you will be called to provide your testimony at the appropriate time. We will now begin the hearing with a legal statement by Nate Boderman, followed by the plaintiff's staff's presentation, the planning staff's presentation, and their report and recommendation. Nate, you're up.
Thank you. Good morning. Now's the time set for the public hearing for the related to the previously identified comprehensive plan and zone change applications. This is a quasi-judicial land use hearing, which means two important things for those participating in the hearing today. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. So testimonies, arguments, and evidence must be directed towards those criteria that have been identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person testifying believes may apply to the decision. Accordingly, anyone testifying here today is asked to please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and parties an opportunity to respond to that issue may preclude appeal to the Oregon Land Use Board of Appeals on that particular issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue precludes an action for damages in circuit court. Once final, these decisions may be appealed to the Oregon Land Use Board of Appeals. At this time, I'll ask the Board of Commissioners to disclose any ex parte contacts, bias, or conflicts of interest. Please indicate the nature and extent of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate in or abstain from the hearing.
Any commissioner wish to report ex parte comment at this time? I do. I met via telephone with Wendy Kellington at the time she was an attorney representing Ms. Murphy in this. Also, Bob Sweeney stopped into my office. We had a meeting regarding, I'm not sure what he does, some type of a consultant planner representing Ms. Murphy at the time, wanting to know what the procedures was. We did not arrive at a decision. We just talked about her situation moving forward on that. Nate, is there anything else I need to say?
No, I guess just for the record, do you feel like you can make an impartial decision in this matter?
Sure.
Okay. Fair enough. Seeing no other declarations here, if anyone testifying here today wishes to challenge the impartiality of any commissioner, please indicate your intention to do so in any written or oral testimony that you may provide. So that concludes the legal statements that we have, and I'll turn it over to Melissa when she's ready, and she will give the staff report and recommendation.
Okay. We are ready for the staff presentation.
Apologies, we're having network issues, so.
Oh, okay. Has it been resolved?
No, we're just having trouble getting on the network, but Christina has the PowerPoint open, so she's going to assist. I was going to be able to control it, but
Christina, do we need to lower the screen?
I'm not able to.
If you would like, we can
Well-
lower the screen for the PowerPoint presentation.
Yeah, I think we better do that so everybody can see it clearly.
Yeah, I'm wondering, does anybody have internet in here?
Sonia, we had this issue yesterday, remember, during the consent agenda, and I think it was supposedly resolved. Obviously, we're having an issue again. So let's just use this and proceed with the hearing today, and we will discuss that later, but thank you. Are you ready?
Yes.
Okay, go ahead, Melissa.
Today, you're here to consider land use application, oh, sorry, could you stay on the first slide just for 1 minute?
Shoot, hold on. There we go.
Land use application Z0079-21-C.
Please speak directly into this. You know, it's hard for us to hear.
With the mask. Yeah,
with
thank you for
masks
letting
on.
me know.
It's quite the challenge, but thank you very much, and go ahead.
The first land use application is a comprehensive plan amendment, and Z0080-21-ZAP is a zone change application. If you could go to the next slide, please, and just stay there for 1 minute for me. The subject property is located in the Damascus area off of Southeast Borges Road and is 7.89 acres in size. It is a vacant forested property with a mix of steep slopes, regulatory wetlands, and designated habitat area. The applicant and her husband formerly lived in the house on the adjacent parcel, 1100. If you could click for me, please. And a couple more times. There you go. The applicant and her husband formerly lived on the house on the adjacent parcel 1100, you can see up on the screen, until they sold that property to a grandson. According to the applicant's testimony at the Planning Commission meeting, she just wants to get a house built for her and her husband who needs medical assistance to live in. This is just for background, but isn't an approval criteria for the applications that you're looking at today. We're just giving a summary kind of here of what happened after the Planning Commission meeting. In follow-up email with the applicant and discussions, the applicant was informed that they could likely receive approval for a temporary dwelling for care on tax lot 1100. The applicant was interested in pursuing that land use approval pathway and submitted an application for a temporary dwelling on 8/30/21, which is file number Z0407-21-STC for a temporary dwelling for care. That application is currently pending a completeness determination. It's not part of these applications you're reviewing, but helpful to understand kind of what's going on the property. If you could go to the next slide, please. The area surrounding the property is forest or agricultural land with sparse home site development. The surrounding zoning districts are exclusive farm use and timber. The area is not served by public sewer or water. If you could go to the next slide, thank you. The applicant is proposing to change the comprehensive plan designation for the property from forest to an urban low-density residential land use designation and a corresponding zone change from timber or TBR to future urban 10-acre FU10 zone to facilitate future single-family residential development on the vacant property. An alternate zoning of R30 was also proposed in the application, which would require a low-density residential land use designation, and we'll talk more about those later in the presentation. If you could go to the next slide, please. Notice was provided consistent with the requirements of the county's zoning and development ordinance and state law. One comment letter was received from Metro supporting staff in the Planning Commission's recommendation for denial. Neighboring residents have called in and emailed staff about the implications of this application for their property. However, no formal comments were submitted by Damascus residents. If you could go to the next slide, please. And click a couple, oh, actually go back, sorry. It's just showing up strange, sorry about that. So I guess the way it's showing up on the slide, this is to illustrate the boundaries of Happy Valley. It looks like they're mostly in white on the slide. So I don't know, it's a little hard to see when it's up on the screen.
I can see it on my computer.
You can, okay,
Very
great.
good. I'm not sure what you folks.
Perfect.
Oh, it's over here, yeah.
Yeah. The subject property is located within the Portland metropolitan urban growth boundary and in the boundaries of the former city of Damascus. While the subject property is not yet within the city of Happy Valley, it is part of an area that is planned to be ultimately annexed into the city through an urban growth management agreement coming to the board for approval later this year. If you could go to the next slide, please. In 2002, Metro Ordinance 02969B brought the entire Damascus area into the UGB, including the subject property. The ordinance changed and added to Metro's growth management policies in the form of amendments and additions to the Regional Framework Plan, 2040 Growth Concept Map, and the Urban Growth Management Functional Plan. Although the county had initiated concept planning efforts after the 2002 UGB expansion, when the city of Damascus was established, those county planning efforts stopped and no other concept planning that would meet the requirements of the UGB ordinance or the functional plan has occurred. As such, the subject property retains the pre-UGB timber zoning, even though it is located within the urban growth boundary currently. Statewide planning goals, Metro's functional plan Title 11 requirements, the Metro ordinance that brought the property into the UGB, and the county comprehensive plan policies all require concept planning to be completed for areas brought into the UGB. Required concept planning consists of long-range planning to ensure efficient urbanization and economic success of the area through a framework for development of mixed-use, walkable, and transit-friendly communities. Concept planning components are required to include a range of commercial, industrial, institutional, and residential land use types, with natural areas and open spaces drawn out. The locations of the land use types should be sufficient to allow estimates of the costs of proposed public sewer, water, and stormwater facilities, as well as multimodal transportation systems. Concept planning also requires inventorying and planning for natural areas, scenic and visual resources, floodplains, erosion hazard areas, and water quality resources. Damascus area-specific concept planning requirements are also listed in Exhibit M of the Metro's UGB ordinance. Concept planning on a lot-by-lot basis can benefit an individual property owner, but it can interfere with and undermine urban planning efforts for a larger area. If you could go to the next slide, please. Since the property is within the urban growth boundary, the county's comprehensive plan has another layer of urban land use classifications that the subject comprehensive plan amendment would be required to comply with. Specifically, the proposed urban comprehensive plan designation would also require moving from the property's current urban classification of future urban study area, so you can see up there on the left under current, to future urban. So we would be moving from future urban study area to future urban to go to the low density residential land use designation. That's how the comprehensive plan has it set up. It's a little confusing, but in the urban area, there's that extra layer of urban land use classification. The comprehensive plan requires the urban classification of future urban to have concept planning completed. So you need to have that completed to move between those two classifications. If the property were to move from future urban to immediate urban, which would be required for the alternate R30 zoning proposed, urban services would have to be in place and available to the property, which is not currently the situation out there. You can go to the next slide, please. For a comprehensive plan amendment, the legal standard of review consists of statewide planning goals and applicable OARs, Metro ordinances, and the county's comprehensive plan. For zone change, the legal standard of review is Section 1202 of the county zoning and development ordinance. You can go to the next slide, please. And you can click a couple times. Based on review and analysis of the evidence on record and the applicable respective legal standards of review, staff finds that the proposed comprehensive plan amendment is inconsistent with statewide planning goals and Metro ordinances, as well as with the comprehensive plan policies and zone change requirements. You can go to the next slide, please. and you can click a couple times. The proposed comprehensive plan amendment and zone changes found inconsistent with statewide planning goals 2, 5, 6, 7, 10, 11, 12, and 14. The Metro Functional Plan. Oh,
Okay, thank you.
can you keep clicking? Thank you. County Comprehensive Plan, Chapters 4, 5, 7, and 11. And I think there's, oh my God. And ZDO 1202.03A for zone changes. Consistency findings for the denial recommendation are included in the staff recommendation provided in the board packet. The majority of the findings for denial relate back to the requirement for concept planning to be completed. You can go to the next slide, please. A public hearing was held on August 9th, 2021 for Planning Commission consideration of the proposal. At that hearing, the Planning Commission voted unanimously to recommend denial as originally recommended by staff. There was no public testimony. The applicant gave a short presentation on the applications. Approved minutes of the Planning Commission hearing are included in the Board of County Commissioner materials. And there were 3 main issues raised and discussed at the Planning Commission meeting. These are, you can keep clicking. These are summarized in the summary that was included in your board packet, the staff summary. And we've already talked about many of these issues previously in the presentation, but I'm happy to go over them more if you have questions. Following the Planning Commission meeting, planning staff have only received 1 comment letter from Metro, which is included in the exhibits in the board packet that supported staff and the Planning Commission's recommendation for denial. No other comments have been received. And if you could go to the next slide. Thank you. That concludes staff's presentation.
Thank you for the staff presentation on that, Melissa. Does any commissioners have any questions for the presentation or the staff person at this time, Melissa Aarons? We will now open up, oh, Martha, did you have your hand up?
Yeah, maybe this isn't the right time for this question, but let's at least get it on the table because we may have other folks want to testify. I've heard that planning staff has worked extremely hard to find another
Martha,
pathway.
can you talk into your microphone?
It's not even on. Sorry about that. Or is it on? There's no light, so I'm assuming it's on. Okay, it's on. I've heard that planning staff has actually worked very hard on an alternative to help solve the issue. So I don't think it's the time for us to go into that.
We
at
can
this moment.
deliberate
Okay?
after
You
the
want to?
public testimony portion,
So,
but you're
so
right.
could you describe what that pathway might be to help the owners get what they need on their property? This may not be the right pathway, but there's a way to move forward.
Sure. As I touched on a little bit previously, it sounds like there is a medical need for care for the applicant's husband, which would allow them to go through the temporary for care land use approval process to get a temporary manufactured home placed on the property. The property is currently owned by the applicant's grandson. If she were to put the property subject to these applications, tax lot 1200, into the same ownership, so her grandson on the title, then she could still place the manufactured home potentially on the subject property. She has options there. The current application has her placing the home on tax lot 1100. So that would be the pathway right now to get her kind of the most efficiently get a home on the property to provide medical care so her grandson can help.
What would that take? Can you give me an estimate?
Once a type 2 application is complete, we try to get a decision issued within 45 days. So it's fairly quickly, and then she can work with the building department, and I think she's already working with septic and building to get approvals for that. So it is a fairly quick turnaround. It does require renewal every, I think, 3 years.
Okay.
But people have them,
Every 3 years, you
renewed.
said?
People have them renewed out there for,
2.
Is it 2? Sorry, 2.
Thank
I don't
you.
work
Renewal
on
would
them
be 2.
very often. People have them out there on the property for, 20 some odd years, and they just keep renewing them. So it can be a longer-term housing solution. Yeah.
Commissioner Schrader?
I'm done. Okay, thank you.
So I want to make clear about something. The medical hardship that you're offering is not unique to this property. As a matter of fact, anybody in the county can apply for that on any property in unincorporated county. Is that right?
I don't, I
Yes, it
believe,
is.
I believe in the,
Your senior planner behind you is
Yes.
nodding her head yes.
yes.
Okay, So although I appreciate that, that does not solve, and the landowner may pursue that avenue. However, it does not solve the problem presented before us today, and I can elaborate on that too. Commissioner Scholl, you're up.
Yes. You mentioned that a concept plan for the area has not been done. Is there a time frame for when that might be done? And second question, has this request been announced to adjacent property owners, and were there any adjacent property owners who objected to the idea of a new residence?
Sure. First of all, for concept planning, it was the previous board's decision, I guess, to assume that concept planning was going to occur from cities such as Happy Valley, who have been annexing and including areas of the former city of Damascus in the urban growth management agreement area. So that was kind of the former stance, that the county was not going to initiate concept planning, that it was going to be a responsibility of the cities in that area. So there's no concept planning efforts currently.
And that concept plan from Happy Valley could be 10 years away, maybe?
We don't know the time frame, but it's likely to be quite a while
And then
still out there.
adjacent property owners' objections?
So we noticed adjacent property owners within a half mile, and we didn't receive any formal objections, just questions mostly, does this apply to my property? Does this apply to the entire city, former city of Damascus? Can I divide my property? Questions like that.
Okay.
I think those questions that came in from adjacent property owners are indicative of the confusion that's exists out there since the city of Damascus disincorporated by a vote of its citizens, and a lot of people out there are in limbo, waiting and expecting Happy Valley to take some action on this. However, it leaves Clackamas County in a quandary, and I tend to address that today. But right now, commissioners, if you don't mind, I'm going to open a public hearing on this matter, and I will call the applicant forward. You will have opportunity to make your case. Ms. Murphy, would you please come forward? We'll wait till this goes up. Please move this right, please move the microphone right here and just almost touch it and talk into it. Please introduce yourself. State your address, please.
Okay, I'm Melva Murphy, address 21142 Southeast Borges Road, Damascus. And my husband's lived on the property for 45 years. And once we started the process to build, like last June of 2019, and with the help of Nicole Cross, I did all the permits and all the template things and such, because they said we could build one dwelling on timber property or forest property, whichever it's
Who
called.
told you that?
Planning Department, Nicole Cross.
Okay, she told you that you could build on the 7.89 acres that is in question?
Yeah. So we
Nicole
started
Cross.
all the process, and I talked to a contractor, and he hired a fellow to put a road in so that we could reach the property through the front property. And then through the planning department, Nicole told me which name, we had to change the titles, or the deeds, the names on the deeds, so that we could do it, because otherwise it'd be in the same tract and we couldn't do it for a dwelling. So I had an attorney and surveyors, and so that was $10,000, and it was probably about $80,000 to get a road back there. And then the contractor cut down 3, 4, 5 trees, and I'm not sure how many in the environmental area, because we had no clue that it was an environmental area. And so in September, I got a notice of violation. And then I came to the code department in the county, and he told me to call EMS or some other company to mitigate the code violation. And I said, well, can't I just pay a fine, or can't you tell me what to do? And he says, no, you have to hire this company.
Excuse me, can I interrupt?
Uh-huh,
Is that the gentleman whom I talked to, Bob Sweeney? He worked for EMS?
yes,
And you hired him to try to mitigate the violation that you were charged with after you were given permission to go ahead?
yeah.
Am I understanding this
Right.
correctly? Okay, proceed.
So, anyway, I don't even know where I was. So got the violation in September. And the contractor I hired, I never signed a contract with him. And then I got the violation notice the end of September. And so he read that and he quit.
He quit?
So, because we didn't have a contract and he was afraid of all the consequences. So that was in September. And then in November, I was told by Nicole Cross that the template wouldn't go through as the entire area of Damascus is within the urban growth boundary. Therefore, the forest dwelling permit would be denied. So EMS then said, well, they'd help me out with that as well, along with the code violation. So, and they did for the 4 or 5 trees we cut down, I have to plant 733, I think there's 123 trees and 600 and some shrubs to where those trees were, and they kind of messed up the ground on the way in, but the ground only had blackberries. So I thought it was kind of, anyway, so that's $10,000 that we have to pay for the trees and shrubs to be planted, which I could have done without, if that code violation guy would have told me at the beginning, we just have to replant that area. I could have gone and hired the company that I hired now, because EMS, I just found out 6 months ago that they don't plant trees or anything, or they don't tell you where to go. So I think it was just a mishmash from day one. And as of today's date, since October of 2019, I've paid EMS $50,000. And they were supposed to be at the meeting last month with the planning division, or Bob Sweeney called me and said that he would be my spokesperson. And I said, well, good, because he has all the really hard facts in his records and such. But he didn't show up, and he kind of made a short appearance, but he couldn't get it connected, and he couldn't get connected by phone. So he didn't say anything, but about a week later, I got a bill for $1,200 from him because he spent 5 hours of his time at that meeting. So I called him and I said, you can't do that. I said, you weren't at the meeting. I had to just kind of hoof it on my own. And so to date, I think I've spent like $200,000 on the project, because even this meeting, I'd already paid for whatever that permit was, and that was $8,000. So I'm just here mainly to complain and let somebody hear what's happening. And I know EMS all along, like this one letter that I was reading from EMS, it says, Clackamas County Planning and has confirmed by email, I can't even talk, but anyway, that Metro Functional Plan requirements are in fact, well, I better put my glasses on. Are in fact amendable to your proposed single-family residential development due to the fact that the current zoning timber permitted one residence per tract prior to the urban growth boundary expansion in 2002, and your proposed development does not exceed that density. So anyway, I got very few notes from EMS saying anything for the last 2 years, 2.5 years. I just happened to read this one, and it was kind of relevant that when I would call Bob Sweeney, like he called me in April and said, I'm going to have a meeting with Tootie Smith by phone. And he said, will you join me? And I said, yes. So he gave me the date and the time, and I sat by my phone, and nobody called. So an hour later, I called the office, and they said, oh, well, he canceled the phone appointment, and he went in person and talked to you. And so then about a week later, I thought, well, he'll send me a note or a letter to whatever he found out. And he finally sent me an email saying, well, everything looks really good after talking to you. Mm-hmm. And so then I thought, okay. But I had just decided in my mind in April just to say, forget it. I'm 200,000 down and nowhere to go. And then I thought, well, he said it looked really promising. So then I thought, well, I'll just keep going to this meeting last month and this meeting this month. And then I find out it's not promising.
I just want to add a point of clarification. When Mr. Sweeney told you he talked to me, and I said it was good to go, and matter of fact, I did not say that. That is a misrepresentation of the meeting I had. I do not have the authority, as chair or any commissioner, does not have the authority to grant building approval. What I told him that he needed to do, and then what you needed to do, is apply for a zone change. I assume that was happening. I just want to let you know that. I'm sorry that that misrepresentation on my part was made to you, but nevertheless, I'm still very interested in hearing. Please continue.
Okay, so the part of the money spent was EMS told me that the county required house plans so they knew how much property, because they told the person handling it at EMS that I could build the house on the site where there was a barn. We could just tear the barn down and build the house right there. And so, anyway, this last summer we tore the barn down because they told us.
Who told you to tear the barn down?
EMS. I called them and I said, are you sure it's okay to,
Who's EMS again?
huh? EMS? Yeah.
Who is that again?
Sweeney.
What? Her consultant, thank you. I assumed that it wasn't the county. Please continue.
So whoever told me, I remember calling and saying, okay, are you sure we can take the barn down? And they said, yes. And then I even, when I called and said, are you sure I should follow through with these permits? And they say, EMS kept saying yes, because Robert, who was in charge of my project, worked for EMS, worked for Bob Sweeney, and for the first 9 months, he kind of gave me a little note once in a while telling me what he was doing, but every 2 weeks I'd get a bill for $1,000 up to $5,000, and then Robert disappeared. So for 6 months, there was nobody in charge. And so somebody else took over, and I think it was Emma at EMS. And she had to learn everything that Bob Sweeney had done with the county for the prior year. And so it's been a mess. But as far as I go into I just need more space to take care of my husband. Mm-hmm. And he likes where he's lived for 45 years.
Sure, I understand that.
And we sold the house to the grandson after we were almost positive that everything was going to go through. So I just kind of feel really exasperated.
Are you finished?
Huh?
Are you
Yeah,
finished?
Yeah.
And feel free, I have a couple questions for you. Let's see, according to my notes, you said Nicole Kloss, was it in June of 2019, gave permission to build on your property? Was that in writing, or was a head nod said, yeah, you can probably do it? Do you remember what type of situation that was?
Just a lot of emails back and forth, and I turned in the application, and then in November, she sent the application back and said, sorry, we made a mistake. And so that's, I think what-
So you were given a go-ahead in writing through an email?
well, the permit hadn't been granted yet, but they said it would be. But then on November 9th, I was told by Nicole Cross that the template wouldn't go through as the entire area of Damascus is within the urban growth boundary. And I think I got that from the email that she sent,
You got that from who?
Nicole Cross. And then she sent the check, or the fee for the permit back, for the application, whatever it is. And so that's, and then EMS was already on board because in September, that's when we got the code violation. And I still get letters every month telling me I'm in violation, even though it's documented somewhere by the county that we're going to take care of it, but we can't do it until the rain comes. Last year we
Regarding your
couldn't do it
code
be-
violation, have you been charged a fine for that?
Not yet, but everything's set
did
up
the
to start in,
Complaint come in from an adjacent landowner or somebody in the area?
apparently so.
Okay.
I don't know how, because we only cut a couple trees.
So my point is this, notice was sent out within 500 feet of all the landowners, but yet you report, no, half mile, whatever, half mile, but yet somebody turned you in after their opportunity to object. And I don't know who's on first, I don't know who's on second, but this whole thing stinks to high heaven. So, Ms. Murphy, what we're going to do, I'm going to ask you to sit down, and I'm going to continue with the rest of the hearing. And then commissioners will have an opportunity to opine on this, and we may have you come back up to the dais for further points of clarification. Is that okay?
Yep.
Okay, thank you. Commissioners, we will now ask if there are any other public officials who wish to testify. Anybody online, Christine?
I do not see any hands raised for public officials.
Okay, thank you very much. Are there any representatives from the CPOs or agencies that wish to testify? You have 3 minutes each.
I am not seeing any hands raised for that either.
Okay, thank you. We will now hear testimony from members of the public who wish to testify. I will call the name, or Christina will call the names online. I do not see anybody else in the room. She will bring you up at the appropriate time, and each person will have 3 minutes. Christina, is there anybody online that wishes to testify on this?
I do not see any hands raised for the online participants.
Are there anybody online?
We have 3 people online.
What
but-
for?
But no hands raised.
Oh, they're just listening.
Yep.
Got it.
Looks like it.
My misunderstanding. Okay, thank you very much. We will now close the public hearing on this portions, and we will begin deliberations. I have a lot of opinions on this after talking with staff and so forth. I know my commissioners probably have comments as well. Commissioner Savas, I see you have a hand raised.
Yeah, apparently we have some other issues that are not directly related to the business at hand, but related to the applicant. And I guess we'll have to navigate those at a different time. So I'm going to keep, I'm only intending to deal with the issue at hand today. I would certainly want to see if there's any other activity or things to look at. I would certainly want to see some supportive material and information, but I'm not prepared for that. So I'm only prepared for the issue at hand today.
And as I am too. Any other commissioners? Commissioner Scholl.
Let's see. The requirement to build a single-family home would require a zone change. But the idea or the option to move in a prefab or mobile home, would that require a zone change?
So you're asking to put a manufactured home on the subject
Yeah,
property?
what I'm trying to get to here is, does Mrs. Murphy have an option of satisfying the requirement for a residence on this property without having to go through a zone change requirement that would enable her to get an approval for a stick-built home on the property?
The the temporary dwelling for care land use pathway is only for manufactured homes, so it wouldn't be a pathway for a stick-built home. It only allows for placement of a temporary dwelling for care on a property or a tract where there's someone living in a main home who can help provide care, like her grandson. So she could place the temporary dwelling for care on the property where her grandson lives, or they could make it a tract by having him on title for the other property, is my understanding of how.
Okay, and is Mrs. Murphy and her husband aware of this option?
Yes, and she's submitted a land use application for a temporary dwelling for care to place a manufactured home on tax lot 1100 owned by her grandson.
And does the planning department, building department see any issues with that application for this particular property?
We're still reviewing it for completeness, but there's nothing so far that would seem like it would be inconsistent with the approval criteria in our code. But it is not complete yet, so I can't say for certain.
And
We're
when will we
reviewing it.
know when that's complete?
We'll know when we issue the decision. We issue the decision within 45 days. So we have to review her application where she's proposing the home to be. There's requirements. It has to be within 100 feet of the main home unless there's extenuating circumstances on the property like natural features or hazard areas, something like that. So there's some flexibility there for it to be located other areas on the property, which sounds like she might want. So we're going to work through that with her as part of the process.
Okay, thanks.
Thank you. You may sit down.
Yeah.
I've done a lot of thinking about this particular application. And in the end, I believe that the denial to this applicant to not be able to use her property for what she wants to build a home would have been granted had the city of Damascus existed, Happy Valley annexed it in, and/or Clackamas County had completed its concept planning. Since Clackamas County has failed in completing its concept planning, we have punished this landowner. I find that reprehensible. A failure of government has denied this landowner to move forward with her right to do this. Now, I believe, and I could be wrong, Mr. Boderman, if this landowner appeals to LCDC, and she has every right to do that, LCDC is going to look at this and say, well, what are we doing at the state level? This is a county problem. Clackamas County failed, and they're going to remand it right back to us. It's going to be sitting in our lap again. And I would not entertain us challenging her at LCDC whatsoever, because we look terrible. Yeah, there's been a lot of political stuff when Damascus decided to disincorporate. It has caused a problem. But we are the government in charge of this right now. I am going to vote not to deny this application. I think this is a black eye on Clackamas County, not because of all the hardship that Mrs. Murphy has gone through in paying $200,000. To me, it sounds like she was not represented well. That is not a county problem. I don't know who's on first. I don't know who said what, but she obviously has email exchanges from whoever I don't know who Nicole Kloss is. She's evidently works in the planning department or did. And she went ahead, as you know, probably a lot of people in the county does, saying, she said, yeah, you can go ahead and build. Maybe she didn't understand the process. Maybe the process was not laid out to her to go ahead with this, and she assumed, because of what she thought, somebody at the county represented it, and then the county person said, oh, no, we're wrong. Geez. What has been offered to her as a manufactured and a hardship is not unique to this piece of property. It's not unique to Mrs. Murphy. It is offered to any person in the county with a similar situation. But I am thankful that staff brought that to her attention. You know, and I have a similar situation in my family. I own a farm, and there's 2 residents on it. My father is 89 years old, and he lives on the original farm, and his grandchildren are there with their children, taking care of him, living in the same structure. And this is a great need across society right now as our population is aging. And I'm so thankful for my niece and her husband for wanting to do this for my father. I'm so thankful for Mrs. Murphy's grandchildren for allowing this happen, because this could be a future homeless situation. And we have all these commissioners crying about the homeless situation, the homeless situation. Well, I've always maintained for 20 years in this state, the land use system leads to the potentiality of a homeless situation. And I think this board needs to carefully consider with compassion about this action and future actions of this. And I'm very disappointed in moving forward. In fact, I'm deeply considering, I will have conversations about how we move forward with concept planning. I think the prior board said no because they assumed certain actions would be taken by Happy Valley. There's some little tiny application coming in from Happy Valley, but it still does not fix the problem. And then I was told that, well, you know, if we allow this, the floodgates are going to open. There's a lot of pent-up demand out there, and there's a lot of anger at government for people not allowing to be able to build on their properties. I think we have an influx of population. I think we have people moving to Clackamas County, not only from other states, but from other counties. And I think we need to start looking at this through a lens of compassion and not be so rigid in that the state says we can't do this, but this is within our own purview that we can allow this. Commissioners, any other comments? Commissioner Scholl.
In looking at this, I don't see the real damage done to future planning by approving this zone change request. I do have a concern that it might start a kind of a snowball effect of property owners wanting to do the same thing. But we live in a time when we have critical housing shortage. And I also have deep concern for property owners in Clackamas County and property rights. So unless we can show in this area where, if you look at the map, there's a lot of houses built in a higher density than what's currently on her property, unless we can show a real damage to our potential for future planning, I think that this zone change should be approved.
Okay, go ahead.
Thank you very much.
Commissioner, Chair?
I think your buttons work,
Oh, I
but go ahead.
don't know where my, oh, sorry.
But thank you for waving and getting my attention. Go ahead, Commissioner Schrader.
Oh, yes, it's going to be one of those days, Chair Smith, I can tell already.
Yeah, go ahead.
Okay, there we go. I want to say a few things to staff, okay? I've been involved in the technicalities of land use for many years, and you are absolutely on target with this technical issue and why technically this piece was denied. You did your job well. If there's been, I think part of the problem, which isn't your staff's fault, what we should be talking about as commissioners is how do we make sure that folks like the applicant, get clear information? Because I also have to be honest, I had real concerns about the consultant as well. That sounded as if the applicant was led down. And I don't know who EMS is, but if I would certainly think that they need to be held accountable, because I think part of this was misinformation. And I've seen this happen more than once, folks, when people hire consultants. So I don't know if there's something planning can do or go to the Better Business Bureau and get accuracy on who is out there who is reputable, who will do the right job. The one time I voted not to follow the technical rules because of the adaptive emotional piece of how people have gone through this. The gentleman broke down in tears. He was so relieved. Okay. So I am inclined at this point to break my rule of really following the technical piece to the letter and having our commission talk a little bit about how we can help our staff make sure we get the right information to people in a timely manner so they don't get victimized by consultants out there. And I don't know how we're going to do that. Maybe we need an ombudsman. I suggest we talk about it. But I would be willing to, because of the circumstances and staff, it's no reflection on your work, I would be willing to, for the second time in my history as a commissioner, vote for not denying it myself, because I understand the technical issues, and you're correct, but there is more to this at this point, and I think that we need to understand that. Now, I don't do this lightly. I've only done it once before. I will do it this time because I think there's extenuating circumstances. I have always been a supporter of land use. I think it gives, oftentimes, order and clarity to how we manage our infrastructure. That's why I support it. It's infrastructure issues, more than anything else, roads, water, sewer, all those kinds of things. So I'm not going to throw land use out, the baby with the bathwater, but I can certainly, because of the circumstances, in a very long-winded way, which I apologize, I would support letting the applicant move ahead. So,
Thank you, Commissioner Schrader. I will follow up with another clarifying statement, too. Commissioner Savas, you're up.
Yeah, well, I am not an expert on this, and I rely upon our staff, and I certainly have relied upon past experiences, but I do have enough information to know, and I also have sympathy for the applicant here in this case, so much so that I want to just ask my colleagues to think a little bit farther maybe than we are thinking here today. And that is, hypothetically, if we were to approve this today, my guess is, with all the requirements to make this happen, Metro, LCDC, challenges and everything else, that we might feel good today, but we actually might be putting the applicant in a worse predicament than they are in today. And I don't want to victimize or see the applicant go through any more hardship of all the challenges and everything else that would likely incur. So I think that the option of putting applying for the medical exception, putting a temporary trailer home on the property nearest Borges Road, I think it was lot 1100, was it? But that option is probably the fastest way to meet the needs of the applicant and for the medical purposes of her husband. So with that, and I'm being sympathetic, and I'm being very practical about that. And the amount of money and time it would take to get this done would probably take a year or two before anything's actually ever realized, if
true.
those challenges are unsuccessful. But I would ask a question to our legal counsel here today. Are those challenges likely, not likely that they would act, but, I mean, they are real challenges that have to be overcome to make this happen, correct?
So just to clarify, since this is a comp plan zone change, the appeal would go to the Land Use Board of Appeals, right? And so then only certain parties at this point would have standing to appeal that. Those that have testified, I think, at this point, it would be only Metro, correct? And so Metro would have standing to testify. We never know unless that party comes out and tells us point blank that they're going to appeal. We just don't know. Once the final decision's made, you have 21 days to initiate an appeal at LUBA. And so if they don't, then the decision becomes final. You can proceed under that approval. If they do, then the appeal process plays out as you've just described. So to the extent that there is a challenge, yes, that would play out through the appeal process. If it's not, then it would be just implementing whatever decision's made by the board.
My experience with some of the folks that are supportive of the urban growth boundary, that are supportive of conservation of the land, would seize the opportunity they have in the past. It's been my experience prior to being a commissioner, during being a commissioner, to step in, and because I think they would see this as a compounding a series of applicants, and without that comprehensive planning at a greater, more response from their viewpoint, probably done more responsibly and broader, and let alone any neighboring jurisdictions nearby that might think that it's an overstep. So for that, I would either ask my colleagues to reconsider where they're leaning, and/or hold this hearing off until we get more information.
To follow up with Mr. Boderman, I do not believe, Commissioner Savas, that one action is exclusive of another. We could grant her the application today, and she still can go with a hardship on her grandson's property. Correct?
That's correct, yeah.
Okay. By granting her approval today, we give her a choice. She did not have that choice. That choice has been taken away from her because of the government's failure to do concept planning. I will hold to that. I would like, before we entertain more questions, Ms. Murphy, would you come forward? I'd like to ask you a question. Do you have you made a decision to go ahead with a hardship in the manufactured home, either on your grandson's property or deeding the two properties together and locating it on this property? Now that you have that available to you, would you pursue that route, or would you decide to build a stick frame home on the 7.89 acres?
I'd rather build a stick home on the 7.9 because I'm a little further away from the grandson, but he's still right there to help.
And you do understand that you could place the manufactured home on the adjacent property and still be away from your grandson's home?
Okay. They told me that I couldn't do that, that I
Well,
had...
what you could do is, you could create one deed, correct?
You have to be legally function as a tract, so.
Legally function as a what?
A tract.
Nate, would you comment on that?
Common ownership, and so
Common ownership,
to
yes.
reunify the ownership of those.
Yeah, put it on one deed instead of having two deeds. It's a matter, you'd have to hire an attorney to do some deed work for you. It shouldn't be all that expensive, although I, at this point, don't want to say that. So you have the option available to you. I want to make sure you understand. You have the option available to you to put a manufactured home on the 7.9 acres but it would all be in one ownership.
So I gave the property to that one grandson, and then I'd make all the other children and grandchildren upset.
Or what you could do is you could have the manufactured home on the grandson's property and continue to pursue, I don't know what the decision here today is. You have options. If you're denied, you have options. You can appeal to LCDC. And I have certainly given statements today as chair that the LCDC would pay attention to the fact that Clackamas County has failed in its concept planning, and therefore it could be remanded to us to make a decision at a later date. And that's a gamble on your part. You don't have to answer to me today, but I'm putting those ideas in your head. I think, Commissioner Fisher, you were up next.
Thank you, Chair Smith. I really appreciate Paul bringing us, laying out the consequences of our decision and the challenge of how long these things can take. I'm interested, Chair Smith, and I wasn't on the commission when Damascus was being incorporated. I was just someone who read the newspaper.
I was here.
But it seems to
I can answer
me
your questions.
that it's not a failure of Clackamas County, but it's, the whole idea of self-determination for the people to determine to create a city, to plan their city, to do all of that is a value that we all respect. I wasn't here, but I don't think this commission or Clackamas County failed. I think it was a challenge of the electorate not being able to get on the same page and being able to determine their future and pass a concept plan, which led to the disincorporation of Damascus. So it's a really challenged situation. But if I'm missing something there, if Clackamas County, am I missing anything? Yeah, I'm looking to you. And I know that might be a political question, and if it's a political question, you don't have to answer.
Not so much a legal issue. Frankly, I don't even know how to respond to that. As far as who would be in charge of concept planning, I mean, you could go a couple different ways with, the county doing it or the city doing it, correct? And, right now, the direction has been that the county isn't going to take the lead on urbanizing that area. The policy decision has been that it's most appropriately left to the adjacent cities to take the lead on that task. And so, again, that's a higher level policy issue, has nothing to do with the criteria of the zone change in front of us today necessarily, but that is, I guess, to provide a little bit of context as far as who can do what, who, may have or may not have dropped the ball. I don't know if that answers your question, but.
Yeah, no, that absolutely answers my question. So I see this whole area, and this gets into policy, but when you look at the maps and you look at where it can be developed, this is, I call it the final frontier of the region. And to make sure that it is planned in a way that takes into consideration all of the infrastructure needs, the mobility needs, transportation, things like walkability, I mean, all of the aspects of water and sewer, and it's a serious endeavor. And my thought has been why I think it's good for cities to concept plan. I mean, we went through the issue in Stafford, and all of the effects of development that relate to traffic, and it just makes sense for cities that are self-determined, I don't want to say sovereign, but you get my idea, entities to do the planning that is closest to the people that live in the community. So I see this as very, very broad. I think our decision today could set a precedent that affects much more than this particular situation. I'm inclined to vote no on this today, but want to encourage my commissioners to really look at the big picture. And maybe Chair Smith is right. Maybe maybe Clackamas County, makes sense for Clackamas County to do concept planning so that this area is developed correctly. But it's not, if we set a precedent that allows for within the urban growth boundary without a concept plan, it sets a precedent that doesn't only affect Damascus, but can affect the other areas in the region as well. And that's a concern. That's a policy concern.
I think the reason why this particular property is so unique, it's just not any timber zone out there, Commissioner Fisher. It's within the urban growth boundary. That is the issue with this. Commissioner Schrader, you're up.
As I said, I technically, absolutely, Commissioner Fisher, you're totally correct. That's the model, the larger policy model. This would be a one-off, for sure. And the reason why we have to be clear with our applicant is that there is a risk, should we let this move forward, that it will get appealed. That is, Commissioner Savas is correct. We can say right now, okay, we're going to let you do it, and it's a one-off, because I think that, again, it's more of an emotional, it's just been a muddled mess, but our staff is technically correct, absolutely technically correct. But you must understand, if we do this today and you try to move ahead with a stick-built house, it could end up in land use appeals issues, and it would really be, in my opinion, much longer. That's kind of what you're facing. Now, the one time I did vote against a land use decision, that was technically correct. There didn't seem to be, it was outside Canby at that time, there wasn't any repercussions. But I think we have to be very clear that there is no guarantee, as Commissioner Savas has said, that any decision that we move forward with today to let you do a stick built is going to stick, okay? I mean, that's the dilemma. I would almost suggest that we, I would suggest at this point, and this is just my suggestion to the applicant, we can vote now, or we can put this off for a week, and we can have you consult directly with our planning staff to help you make a decision about what route you want to take. We could say yes to you today to build a house. We can do that, but there's no guarantee that other external folks will get involved and appeal the decision. That's the bottom line. That's the risk you take. And then you're through a whole land use rigmarole again.
Go ahead and answer that. Please pull up
So
here.
Tony, do you have any other?
I'm going to let her answer you.
So if I go ahead and put the hardship manufactured home on my grandson's property, then I can still own the back piece of property, and someday maybe it can go to my kids and grandkids. And
Yes.
so maybe that's probably the way I'll still try to go, but it still seems really difficult turning in the application. Now I'm waiting for the sewer, because we have to probably
You have a septic,
tie in the
yeah.
Well,
sewer.
is there sewer in the area, or is it septic and wells? I believe it's septic and wells, as I was told before. So you would have to put in now you may have to put in a septic system for the hardship too. I don't know.
Well, they said I tie into my grandson's.
Oh, that she can tie it to her grandsons? Can she also use the same well from her grandsons?
I don't work in the septic department, so I defer to them, but it's my understanding that that's possible, from what she's been communicating with them.
We're not, no, we're not giving approval of that, but under certain conditions, yes, that could be possible. Okay. Okay, well, I am not going to pin you down on a decision today, because I believe this decision needs to be made on the face value of what's presented to us here today, and I don't disagree with Commissioner Savas. However, I have a different philosophy in land use. I've been dealing in land use for probably 30 years in this state. And when I was in the legislature, I successfully passed many, many land use laws that Democrat governors signed. And those are still on the books today. If I was in the legislature again, I would believe I would still have the same type of success. However, our land use system has morphed, and I believe it has become more onerous, and I do believe that people's property rights have been taken away. And that's where I'm coming from. Martha, have you finished?
Yeah, I just wanted to say, we do have a different philosophy of land, we do have a different philosophy, Chair, of land use, although I will agree with you in that it has continued to grow in complexity, and this is not the first citizen that we have had in front of us who's been totally mind-boggled, because, I mean, we have people who are professionally educated with 2 or 3 college degrees to I mean, and masters and doctoral levels, to do this, so
But
it's.
yet,
it's-
we're making the decision here today. Those
So,
folks
so
aren't.
I guess my question to you then is, if we are being very clear with the applicant that should we say yes to letting her build the stick built, that there is risk, and you would have the choice either way, but I would strongly suggest that you consult with the planning department, because I think that you need to be very clear about the risk you want to take and timing and those kinds of things.
Yeah. Commissioner
So,
Savas,
That's fine, I mean,
sorry.
pardon me?
My husband's 88, and it was already been 2.5 years, so
Okay.
if I don't get a bigger place pretty soon, both of us are gonna
Yeah,
go crazy.
okay.
Commissioner Savas is up. I want to make a quick point. Available at Clackamas County is a pre-application process that you can sit down and they can walk you through every single procedure that you would need to do. I would suggest you take advantage of that. Staff, I would like you to give whatever this applicant decides to do extra attention to this, knowing her unique situation. But that's available to anybody in Clackamas County. Commissioner Savas.
Well, 2 things. First, after getting the advice and the preparation for this earlier, a week or so ago, I came prepared with the questions and the thinking and the rationale around the decision at hand and the Planning Commission and the staff recommendation. So I did not explore, and I'm not prepared to really make a rational decision, in the alternative to the recommendation. So I'm not prepared to entertain, Commissioner Smith, what your suggestion is as far as allowing this to happen. I am very concerned, and again, with sympathy, and and I care about our constituent, our applicant in front of us, and I've seen other people go through these very difficult and challenging things, and it's sometimes very, very traumatizing. The years that go by, the yes today, no tomorrow, the anguish of it all, and if you were a family member, I would encourage you to, put the structure on your son's property,
Manufactured home.
the manufactured home on your son's property, and take the fast, easy, lowest cost route with the least amount of anguish. I would recommend that to a family member. In your particular circumstance, I'd recommend that to a friend. But I'm wearing a different hat here today, and I don't want to see you go through any more anguish.
I know,
But
I'm
yeah.
about ready to.
So therefore, if there is consideration of passing this, which is, I did not come prepared for that, then.
Well, it's in our script,
I
Commissioner
am
Savas.
certainly, I'm not ready to do that,
All
so.
right.
just wanna make
That's
that
fine,
perfectly
and
clear.
you need to vote the way that you think you
Yep,
need to
I will.
vote.
Well, Commissioner Chair, should we vote today, or should we give the applicant
Well,
some time
I-
to have some?
Well, the thing
Conversation.
is, like I said, one action is not exclusive of the other. We could have vote today to approve this, and she can have
Okay.
she can put her manufactured home on her grandson's, slam bam, thank you, ma'am. None of this is easy in the building industry. You go down and you think you're going to buy, a 3-bedroom, 2-bath, extra-large manufactured home, there's still difficulties with that. There are much more difficulties building a stick frame home in today's climate. I'm just telling you that. I would agree with Commissioner Savas. If you were my family member, I would say yes. I think a manufactured home on your grandson's property for now, if they are willing, would be acceptable. And it doesn't have to be right next to him. I think you might have space available. You know, it just depends on your husband and your husband's condition, and there's grandkids running around, and is he okay with that? Now, I'll go a little personal here. My father, who is 89 years old, is living in this, it's a very large home, with my grandson, with his granddaughter, and they have 3 little kids, okay? And there's a new baby in the house that was born in January. And he was so excited to have a baby in the house. You should have seen that old man. It gave him life, it gave him purpose, and it was it was a blessing on their family. So I do believe families are best when they're together like this. I'm going to entertain a motion to approve Z0079-21-CP and Z0080-21-ZAP. Commissioner Scholl.
So moved.
Thank you. I made the motion. Commissioner Scholl has seconded that. Commissioner Schrader, you have a comment.
I will second that.
You will second that. Thank you. Yes. The motion has been made to approve by myself and seconded by 2 of my commissioners to approve Z0079-21-CP and Z0080-21-ZAP. Any further comments on this? Commissioner Fisher.
Yeah, I can see how this vote's going to go. It'll be a 3-2. What I would suggest is that Nate help us with narrowing this decision to this particular situation. As Commissioner Schrader has stated, it's a one-off. If you could help us so that this does not apply to other people with property in Damascus that will continue to pursue this, because this is a serious issue for the region. Planning Damascus in a way that protects livability, mobility, transportation, quality of life is really, really important, and it needs to be planned. We really can't have a series of one-offs in Damascus. We have to be more thoughtful about that, and that's the responsibility of government and this board. I will continue to be a no vote because I really believe in appropriate concept planning, but Nate, could you help us narrow this particular decision to these particular facts?
Yeah, thank you for that. Nate, there's a motion on the table,
Yeah.
but what would, you want to answer, Commissioner
Well,
Fisher?
just a clarification on process more than anything. So you'll take an oral vote today, and then we'll come back at a future business meeting with findings that you will adopt at a later business meeting. That will be the final decision. So you can review those findings. If you have any questions or comments or concerns, at that point, we can address the way that we've justified whatever decision you make here today. And just further to the point, these are, again, quasi-judicial applications, and so anytime you would get a similarly situated application, it would come before you for a decision. And so this isn't legislative in the sense that it is establishing broad policy or direction. This is a one-off application. If something similar comes in the future, presumably it would come before you again to make your determination.
So when we bring those findings back to the board meeting, can we put sideboards on this?
Sideboards meaning?
Well, I don't know. What findings are you talking about?
Well, we go and we evaluate the criteria and we evaluate the proposal, and it is consistent with the oral decision that you make. And so we, again, evaluate what we need to evaluate according to state law. And as far as sideboard's conditions of approval, there may be, something is to make consistency with our own code, state law, so on and so forth. We aren't going to draft a sideboard on our own necessarily that would say it only applies to this property, or that to the extent that that's what you're asking.
Okay, thank you. Commissioner Savas, you're up.
Well, I appreciate the clarification by Mr. Boderman, and that'll give me some time to consult with him deeper on this. I don't want to belabor this. It's going to be very complicated. I have a lot of questions. So between now and then, I'll be
And I
looking
would
to chat with you
appreciate-
and also our planning staff, and also, with anyone else that can contribute to understanding what that journey would be like for the applicant.
I would appreciate any commissioner following up on this particular issue, and with the planning staff, following up with the commissioners as well. With that in mind, I'll call for a vote. Christina, call the poll.
Okay. Commissioner Fisher?
No.
Commissioner Schrader?
Aye.
Commissioner Savas?
Abstain.
Commissioner Scholl?
Aye.
And Chair Smith?
Aye, motion passes 3-1-1.
There's two alternate proposed zoning districts, so you would need to specify if you're approving the R30 zoning district or the FU10 zoning district.
Well, according to my notes and my script that was presented to me by staff, it's and CP and ZAP, so I don't know what you're talking about.
So there's a comprehensive plan amendment, and then there's a zone change application. The zone change application had two proposals of two different zones were proposed.
Nate, help me on this.
So the question, so the comp plan change is the same regardless, correct? And so the question, I guess, before you is whether the zone change that you're approving relates to the FU10 zone
Or the R30 zone.
or the R30 zone? And what's,
Okay.
in a nutshell, what are the differences between, Jennifer, do you?
Ms. Murphy, would you please step aside, and Jennifer, please state your name.
Good morning, Jennifer Hughes, County Planning Director. So to clarify, the applicant proposed two alternative zones, and of course, we recommended denial, so now with you switching to approval, you need to clarify in your motion which zone you're approving. The future urban 10 zone means you're applying an urban plan designation, but the land itself remains in a holding pattern. So she couldn't do, for instance, a 40-lot subdivision. She would get one house with the FU10 zone. If you were to approve the R30 zone, what you're saying is that this land is immediately urban, and it could be subdivided into 30,000 square foot lots. Our comprehensive plan does not permit that without sewer, and sewer is not available. So
Okay.
in my view, the FU10 is really the only
Okay, it is the
Option.
intent, Jennifer, it is the intent of this commission, you heard one home on this piece of property. This is what has been presented to me today in the script, Mr. Boderman. Did you review this script?
I drafted the script.
You drafted the script. What is at issue today?
Well, it's the comp plan and zone
Well,
change application, yeah. And
Regarding
so-
the motion that is here, and it's the same if we denied it, it's the same if we approve it. And frankly, what I read, I'm not sure what's urban, what's
No,
rural.
and that's fine. We never know how these things are absolutely going to go, and so we try to build some flexibility into the script. If you want to modify the recommendation was to deny. If you want to modify that, which it sounds like that's the will of the commission, we can't, there's an infinite amount of possibilities out there, right? And so what we're trying to do is help you work through what that modification looks like. And in this case, you have a choice of two zones. I mean, that's what the applicant
We need
is.
another motion. Or are we okay?
Let's go ahead and modify the motion to approve these applications and clarify that the zoning to be applied would be an FU10 zone.
The intent of what I didn't hear.
I'm sorry?
We're going to modify the motion to what?
To move to approve Z0079-21CP and Z0080-21ZAP, and to apply the FU10 zone, to
For a-
approve to apply the FU10
Okay.
zone.
So moved.
Thank you. Seconded.
Yes.
Thank you very much for the point of clarification. It is the intent that one home is allowed on the subject property. We will go back and do our due diligence before this is brought before our business meeting. Are we time sensitive on when this is brought forward to the business meeting?
We don't have a state deadline to make the decision. Typically, we try to get these back to the commission within a few weeks.
Well, let's take our time on this. Let's take our time. We don't have to be back in 2 weeks on this. Let's take our time so all the commissioners can be heard on this. Okay, there is a motion on the floor. It's been seconded. Christina, would you please call the poll?
Yes. Commissioner Fisher?
No.
Commissioner Schrader?
Aye.
Commissioner Savas?
Abstain.
Commissioner Scholl
Aye.
and Chair Smith.
Aye, the motion passes 3-1-1. Thank you very much for the point of clarification, staff. Any other comments for us today? I want to thank
It's
Martha.
just been
I-
glorious today.
Yeah,
It's just
yeah.
glorious.
I want to thank you all for your, each commissioner had comments that are worth noting. I appreciate the sensitivity applied to this. I appreciate all your opinions, and let's go forward.
Chair
This
Smith.
meeting is a
Really quick, sorry. Last page, please direct staff to draft an order reflecting the decision.
Yes, now that the applications have been approved, I will direct staff to draft an order reflecting today's decision and include it on the agenda for the board's adoption in a future business meeting.
Thank you.
I kind of thought I said that.
You did, I just want to make sure the record was
I
clear.
thought I said that. Meeting adjourned.